Hello, everybody. Welcome. And again, thank you to the Westhampton Beach Library. Today, we are talking about estate planning for women. Why, right? That's the big question. So the library approached us and asked us to do a topic related to Women's History Month. So I got to looking on the government website for Women's History Month. It's womenshistorymonth.gov. And they talk about Women's History Month being, and I'm going to read this from their site, commemorating and encouraging the study, observance, and celebration of the vital role of women in American history. That is such an important mission. And when we look at the vital role of women within families, within relationships, within the economy, that is what we're talking about when we're talking about estate planning for women. In the end, the documents, the considerations, they tend to be the same regardless of the gender of the person or the marital status or any other status of the person. But we really want to take this moment and recognize the fact that after many years of women being ignored or not taken into account in these conversations, women are really at the forefront of a really exciting change in our world. I'm involved with the Katz Institute for Women's Health at Northwell, and the doctor who runs it always says, we're finally studying women medically, not like they're just little men, because we aren't. We're very different, biologically speaking. And so when we talk about estate planning for women, I like to use that same concept and really looking at these same questions that I would ask somebody regardless of gender and ask them, what is it that matters most to you? And when we look at these topics, one, we want to get your attention, right? Estate planning for women. Let's pay attention. Let's remember why this is such an important topic. Women tend to be caregivers. They tend to care for their parents, their children, their spouses, regardless, again, of gender of the spouse. They make a lot of the decisions for the family. And what a lot of estate planning attorneys will tell you is two spouses may come into a meeting, and many times it is the female, if it is a two-gendered couple, it's the female who tends to be driving the conversations and really has strong feelings about how to properly care for the next generation. And so we want to honor that and pay attention to that. Also, women have a longer life expectancy than men. So traditionally, in different sex couples, we find women often inherit twice. They inherit when their parents die, and they inherit when their spouse dies. They take over the assets, two big changes within their lifetime. And that is something to pay attention to. Women also tend to be very charitable. McKinsey did a study, and they recently found that there's a massive transfer of wealth that's about to happen. The male baby boomers are going to be dying, and that's going to transfer wealth very possibly to either, yes, to daughters, but also to spouses. And also we have the fact that women are entering the workforce and taking over the workforce at greater rates than ever before. And so this shift, according to McKinsey, is going to put women in charge of about $30 trillion of assets by 2030. That is a huge shift. And so we're honoring that today, and we're just going to discuss estate planning topics with that as our background. So all that being said, what is estate planning? When we look at estate planning, we look at it very holistically. We look at it as, what do you need to make sure that you're cared for while you're alive? And what are the things that you need in place to make sure that things go the way you want them to upon your death? Those are the topics that we're looking at. So we talk about these main topics. First, we have what we call advanced directives. Those are healthcare documents. We talk about power of attorney. We talk about wills, and we talk about trusts. And these are the topics that I'm going to be discussing today. In the background of a lot of this, we're also going to be talking about long-term care costs and how to properly cover those costs. And we'll talk about taxes. So when we're talking about advanced directives, we're talking about the healthcare documents: healthcare proxy, living will, HIPAA release form. A healthcare proxy is a document that says who will make your medical decisions if you're unable to make them for yourself. So if you are deciding, okay, if I'm have a long-term incapacity like Alzheimer's or dementia, who is going to make my medical decisions? Or if I have a short-term incapacity, like I'm under anesthesia or something that's not going to last indefinitely, same thing, who will make medical decisions for me in those times? There's also a rise of women who are single and not married, and therefore these documents are even more important because the default might be your parent or your sibling who is not someone that maybe knows your wishes or you would want to make those decisions for you. Unlike those who the default would be a spouse or a child. And so we want to make sure that you're making thoughtful decisions about who will make the decisions you would make if you could make them for yourself. The healthcare proxy needs 2 witnesses over the age of 18. I wouldn't recommend having family members or anybody who's certainly not anybody who's named in the document be your witnesses. And they just have to attest to the fact that you signed that of your own free will. Doesn't require a notary, doesn't require a lawyer. Next is a living will. A living will is a document that states what kinds of decisions you would want your agent to make. So if you're in an irreversible state with no reasonable expectation of recovery, would you want your agent under that healthcare proxy to remove or to turn down certain treatments? And that's what goes into the living will. The authority for the agent to remove or withdraw those treatments, and a general statement that you wouldn't want to be indefinitely kept alive in those circumstances where there was no reasonable expectation of recovery. And then a HIPAA release form. This is a document that says who can receive your medical information, who can get copies of your medical information, speak with doctors. This does not require incapacity. So for the healthcare proxy and the living will, they are only in effect if you're incapacitated. So take the individual who is not incapacitated, but they've signed a healthcare proxy. And we've seen this sometimes. A daughter will call up us and they'll say, I called the doctor and I asked them to tell me about my mom's medical information, but they said they wouldn't tell me. And I said, but I'm the healthcare proxy. And the doctor's office said, that's great, but your mom hasn't been deemed incapacitated. So you must be deemed incapacitated for that healthcare proxy and living will to come into play, whereas that HIPAA release form doesn't require that. So if you want someone to be receiving medical information on your behalf, then you can do so through that HIPAA release. Although they still can't make medical decisions, that is up to the individual until they've lost that capacity. And then we have the power of attorney. Power of attorney, I talk about as handling the finances of your life, the business of your life. So say you need somebody to access your long-term care insurance plan, to take a larger distribution, or to set up your required minimum distributions from your retirement account, to help pay the bills, to deal with any kind of medical insurance billing. These are all different things that an agent under a power of attorney can do for you. Now, not all powers of attorney are created equal. So a power of attorney document only gives the powers that are listed in the document. So if I want my agent to be able to do a specific thing, I need to put that in the document as a specific item that my agent can do for me, or else my agent doesn't have that power. I sign the document, I have it notarized. The notary can be one of 2 witnesses. So I need myself and 2 other people in the room, one of which is a notary, to witness my signature. And then my agent, the person I'm naming to act on my behalf, the person or persons, will then sign and have it notarized before they can act. Unlike the healthcare proxy, most powers of attorney do not require incapacity. That means that you are conferring these powers on another individual regardless of your mental status. And so when you see somebody saying, I want a durable power of attorney, durable means that it's in effect now, and it's in effect if you become incapacitated. So all powers of attorney in New York are durable unless they state that they aren't. The only reason you would probably make a power of attorney not durable would be if it was only for business purposes, but not for these personal reasons like estate planning. So you want to make sure that your power of attorney is up to date and has all the powers that might be necessary in the future. Further on the power of attorney, that law recently changed. So as of June 13th, 2021, we have a new power of attorney law in place. So if you have an old power of attorney who stated that somebody would be named as your agent, and you signed it before June of 2021, it is still valid as long as it was valid when you signed it. However, if you've signed one since June 13th, it has to be on the new form and comply with the new statute. So you want to make sure that that was done properly. I will tell you that I have never seen a power of attorney that was downloaded from the internet that in the end was executed properly and had all the powers necessary. And so if you have done your own power of attorney, you probably want to have that reviewed by a lawyer just to make sure that everything's in good order. The problem with the power of attorney is if you don't have it in good order and then you lose your mental capacity, you can't sign one. And then you're in a position where there's nobody who can act because the document you're relying on is not a valid document. And there's not really much leeway in the law on that if it's not valid. So you really want to make sure you have a good, strong document. When I talk about the healthcare proxy, I often have people who say to me, well, who should I name as healthcare agent? Who should I name as power of attorney? And I always respond that you should name the person that you think would act most closely to the way you would act if you could speak for yourself. And I have a lot of women specifically, and unfortunately, or for some reason, I'm not sure why men don't tell me this as much, but a lot of women tell me that they don't believe that their significant other will be able to do what's necessary if they need to, as they often call it, pull the plug. Many of my female clients feel that their spouse might be unable to make the hard decision to let them go. And that really, I find women think that through quite a bit when deciding who to name as their agent. And so it's really important to think about that. Who would do, might not be the easy answer, but who would do what you would do if you could speak for yourself? And that is the most important thing. Not who's the oldest child, not, who's, you could take proximity to you into consideration, but really who's decisive and who would follow your wishes. And those are the most important things. And for the power of attorney, it's those items, but it's also who does well with money, who is responsible, who won't be overwhelmed by the responsibility of calling these insurance companies, of making sure things are being properly handled. So you really want to think twice about who you name. Unfortunately, we find a lot of people in a situation where they feel kind of pushed or bullied into naming a certain agent. And then when it comes down to it, that agent really isn't up to the task, or worse, does a bad job and puts you in a financial problem. But you really want to make sure that you're naming someone thoughtfully and not just based on these preconceived notions of who it should be. Next, I'm going to talk about wills. So a will is a statement of your wishes. So a will says how your assets are to be distributed at your death and who should be in charge of doing so. That's your executor. Your will is a list of your wishes. You are nominating an executor. No one is the executor or is officially appointed as executor until a court process called probate is completed. So if you want a certain person to be your executor, you can name it in the document, but then the court still has to appoint them after this process. This process only really happens if you have assets in your sole name with no beneficiary. So the sole name or no beneficiary, let's run through some options. So you have a home with a deed. That's in your sole name. Nobody else owns it. Well, then that's going to go through probate. You have a checking account that's joint with another person. That doesn't go through probate. It goes to your joint owner. You have a retirement account of sorts with a beneficiary named. That does not go through probate. That goes to the named beneficiary. So you want to go asset for asset and determine what is actually going to be handled through the will. And then when you determine what that is, then you can determine how the will should be written. I want to point out, which I should have pointed out at the beginning, that these are the rules according to New York State. While other states might have similar laws, everything we're discussing today is New York based. It's based on New York law. And so that's really the only thing we're discussing. The other disclaimer, which I usually give at the beginning, but didn't, was that this is all meant to be educational. This is not meant to be legal advice. So if any of the topics that I'm talking about ring true with you and make you feel like, wow, I should really be checking up on my documents, I should be making sure things are in order, well, in that case, you should speak to an attorney and get specialized, individualized consultation and advice. So this is really just meant to be educational. So when we talk about probate and we're talking about those assets in your sole name with no beneficiary, that's what goes through this process. Now, what is the process, right? So the process is that you apply to the court. The executor who's nominated in the will apply to the court and say, here's the original will of so-and-so, here's their death certificate, and I'm asking you to admit this will for probate, to rubber stamp this will and name me as executor. And then your legal next of kin are notified as to the fact that this will is being entered for probate, and they're given an opportunity to come in and contest. So when you think about it, you don't want your will to go through probate, and you don't want to give this opportunity to contest if you're disinheriting your next of kin or if you don't know who they are. So for example, if I am a single woman and my next of kin, my parents are deceased, and my next of kin are my siblings, but my preference is not for my assets to go to my siblings, and they're going to be upset about that, well, then I probably want to avoid probate because I want to avoid them having the opportunity to come in and contest and cause money to my estate, cost to my estate, delay in the assets getting to the place I really want them to go, wherever that may be. So you want to think about, what is the probate process going to look like once you're gone? And is that okay with you? Whatever the answer is about what it's going to look like, is that okay with you? You also might want to avoid probate, like I said, if you don't know who your next of kin are. So if I am unmarried, no children, no parents, no siblings, my parents were only children. So one of them might have had a child who was my cousin, but I don't really remember. And I wouldn't be able to locate where my next of kin are. Well, then I also don't want to go through probate because my estate would have to pay a pretty penny in order to determine where my next of kin are likely to be and to notify them. And that is not something we can get away with not doing. The court requires it. So probate requires that these people be notified, even if I'm not leaving anything to them, even if I don't know their names. So you might want to avoid probate. Another reason you might want to avoid probate is if you own property in multiple states. So I have a client who, her husband recently passed, and she has some real estate in New York where she lives, and she's looking to potentially relocate for part of the year and buy something in a warmer climate. And so then she's going to own property in 2 different states. If that's the case, then she will have to probate her will in 2 different states. And so again, we may want to avoid probate in order to avoid the extra delay and cost to her estate of multiple probate proceedings. So how do we avoid probate? Well, I told you one way is we name joint owners on bank accounts. We have beneficiaries listed on certain types of accounts, or we can create a trust. And very often the trust is a good way to do this because it has certain creditor protection for your beneficiaries. It has certain ability to pass things very quickly without a court process, but still have a central place for your estate so that if taxes are due for estate taxes or your final tax returns or the cost of cleaning out your residence can all be borne by the trust before beneficiaries get their assets. So you might want to look into creating a trust. There are many different types of trusts, and every type of trust is really just a different name for the goal of the trust, and then how we draft the trust will change it. So for example, a revocable trust, it has no, generally speaking, if I create a revocable trust for myself, I'm not limited at all. I can do whatever I want with the money. I can take it in, give it out, whatever I want, buy things, sell things. I am not restricted in any way with that trust. But it also doesn't give me any creditor protection or any estate tax protection or any Medicaid protection. It is just to avoid probate. And we're doing that for a lot of clients based on those circumstances I explained earlier, but you really want to look into if that's the right thing, or are you trying to protect for something? There's irrevocable life insurance trusts, which are trusts that are created specifically for the purpose of removing the death benefit of a life estate from your taxable estate. And I'm going to talk about taxes in a minute. There are Medicaid asset protection trusts, which are a different type of irrevocable trust, which are still part of your taxable estate, but protect assets in the trust if you need to apply for Medicaid, for home care, nursing home care services. And there's many other different types of trusts. It all just depends on what the goal of the trust is. What are you trying to achieve? And then how can we draft the document so that it looks the right way and does the right thing? A trust is a document, first and foremost. We create the document. The document has the rules of the game. But by signing that document, you are creating a legal entity. It will either have your social security number or a new tax ID number. Regardless, it can own things. So just like you can own a bank account and then you can use the money in it and then you can give it away and close that account and open up a different account with the same money, so can the trustee of the trust do those things within the trust. And who the trustee is, again, depends on the type of document that you have and the purpose for having it. I'm going to talk a little bit about estate taxes now, and especially about gifting, right? So in New York State, we have no gift tax. Federally, each individual person can give away $16,000 per year per donee. So if there's 10 people in the room with me and I want to give them all $16,000 this year, I can do that. No gift tax filings have to be made. There are no taxes paid, and there's no responsibility. However, once I give any one of those people anything over $16,000 in that calendar year, I now have to report it. I report it through a gift tax return. So let's say I decide to give one of those individuals $20,000. That means that a $4,000 gift was taxable. I would file a gift tax return. I would not pay taxes likely at that time. However, that $4,000 gift would be a gift that would go against my lifetime exemption, which according to the federal government is currently over $12 million. And if I gave as many $4,000 gifts as I could, if I hit 12 million with my life and death gifts, then there'd be a tax. That 12 million number is going to change. So right now it's 12.06 million you can give away federally without any estate taxes. That's per individual. So a spouse is, if you have a spouse, it's double. However, that is going to sunset. And as of January 1, 2026, anyone who dies after on or after January 1 of 2026 is going to have a much lower exemption level. It's going to be 5 million indexed for inflation. So probably around 6 million. So if you think about it, if I give away a $4,000 taxable gift during life, that's 4,000 of the 6 million I can give away. If I only have $200,000 to my name, I'm never hitting that 6 million number. There will never be a gift tax on my estate. So that's how gift taxes work with the federal government. New York doesn't have a gift tax. So in New York, if I give that $4,000 gift, as long as I live for 4 years beyond that gift, 3 years beyond that gift, there is no gift tax. However, if I die within 3 years, that $4,000 gets added into my total estate value, and I could potentially have an estate tax. The New York State exemption level is 6.11 million. So if I give away less than 6.11 million, either in the last 3 years of my life or at my death, then I have no estate taxes. I don't have to worry. But New York also has what's called a cliff. So I like to describe it as this. There's no tax, no tax, no tax, no tax. We hit 6.11. We level off for a minute. And when we hit 105%, which is about 6.4 million, a little over 6.4 million, we fall off the cliff and we're taxed back from $1. There's no exemption. So you go from having no exemption to having, you know, over $500,000 of taxes owed very, very quickly. So you want to make sure that when you're doing your estate planning, you're planning for the fact that you might fall off the cliff if you're over the $6.11 million. So that's how the estate taxes work. Federally, over the exemption, you're only taxed on the overage. It's a higher percentage, of course, than New York, and there's a complicated formula where you get credited for state-to-state taxes paid, et cetera. But if you are a New York State resident, we're really planning for that $6.11 million number, especially because the federal is likely going to go back down to that amount. And again, that is doubled for spouses. It is 6.11 per spouse. The other thing is that in New York, it's what I like to call use it or lose it. So if I die and I don't use my whole 6.11, that's it, then it's over. Whereas with the federal government, if I don't use any portion of my exemption and my spouse files the right documentation, then when my spouse dies, they have their exemption plus whatever's left of mine. We can share exemption between spouses. That's what we call portability. And so that's really great on the federal side, but we don't have that in New York. So we have to be careful when planning that we're planning for both federal and New York type of planning. The other thing that I want to talk about are retirement accounts. The retirement accounts, tax deferred retirement, there was a new law that was passed that went into effect on January 1 of 2020 that changes how we can inherit retirement accounts. It also changed our required minimum distribution date from 70 and a half to 72. But most importantly, it made it so that other than a specific group of individuals, if I leave behind tax deferred retirement, my beneficiaries have to take a 10-year payout. So that means 10 years from my date of death, they have to fully distribute the account. And if it's tax deferred retirement, realize they have to take a full distribution that is taxable. So their taxes can go very high. If I have a spouse, a disabled child, somebody who's within 10 years of my age, all of these people can get a longer payout, what we call a stretch. But for the standard, you know, if you're leaving to your child or to your grandchild or something like that, it's a 10-year payout. So we want to keep that in mind. Again, when we're doing planning, who are the beneficiaries on our accounts and does that make the most sense? The other thing that's really good about trusts is that when you put it, let's say somebody has a house. I have a client who, this just came up recently, has a house and received that house from family members. Her parents gave it to her, but they were still alive. And mom and dad had bought it for $20,000 and they gave it to the daughter and then subsequently died. And then the daughter went to go sell it. And she had an enormous capital gains tax because now, I mean, we all know, especially in Westhampton, how the property values have skyrocketed. She's selling this property for $2 million and she's paying capital gains tax based on mom and dad's basis, which was $15,000 back when they bought it. Now, if mom and dad had put that property into a trust, a properly drafted trust that was given to the daughter when they died, then she would have gotten what's called a step up in basis to their date of death value. And when she turned around to sell it, she'd have a lot less capital gains tax to pay. So let's say when mom and dad died, it was worth $1.5 million. And then fast forward, she goes to sell it and now it's worth $2 million. She would only be paying capital gains tax on that $500,000 gain, not on the gain back from $15,000. So there's a lot of really good planning we can do with trusts that protect assets and also protect us from these large capital gains tax and transfer property in an easy way. I'm going to pause now and see if anybody has any questions. As Liz said, you'll see on your toolbar, there's a section that says Q&A. You can type questions in there and we would be happy to answer them. I'll add that if there's any specific topic that you were looking for us to discuss today, you can also just put that in the chat because I'd be happy to address it. Okay, no questions yet, so I'll keep going, but please do add into that Q&A if you have them, and I can, I'll stop again in a little bit to address. The other thing that we're often discussing with individuals, and certainly with the caregivers, which is often the spouse, the female spouse of an individual, is cost of long-term care. Now, some people bought long-term care insurance, and that's great, and it's enough, and they can use it to pay for their care. Some people have enough assets to privately pay for their care, also a wonderful opportunity. However, there are many who, while they might have made even a decent living, the cost of long-term care would be crippling to them or to their loved ones if it had to be paid out of pocket because they can't afford it. Often home health aides are, $20 to $30 an hour, if not more. And that can really rack up when you have someone who needs persistent long-term care. And this is where people generally avail themselves of the Medicaid program. Now, a few things that I just want to point out right off the bat that I think come up a lot, which is if you have Medicare and then you need long-term care and you apply for Medicaid, you keep your Medicare. Your Medicare still pays your doctors, your hospitals, your prescriptions. All of those things are still the same. So you won't lose your providers. You won't lose your doctors. This is a reason a lot of people are concerned about Medicaid because they're afraid they're going to become a Medicaid patient and their doctor doesn't take Medicaid. That's fine. Your doctor doesn't even really have to know because they are being paid through Medicare. Medicaid is another type of health insurance that is beyond Medicare. It pays things Medicare doesn't, but it calls itself the payer of last resort, meaning it's not going to pay unless Medicare has turned down and it's a valid Medicaid service. So that being said, there's two main Medicaid programs that we look at. One is home care and one is nursing home care. The current rules today, March 24th, 2022, are that there is no look back for home care Medicaid. If you are eligible by the end of this calendar month, you can apply the first of the following. So if I'm eligible this week for Medicaid, I can apply for April 1 for home care Medicaid. There was a law a few years ago that passed saying there'd be a 2.5-year look back for home care Medicaid, but for many reasons, this has not yet been implemented and the status of that is unclear of when and if that will be done. You will also hear that the current budget that is being discussed in Albany, which is due on April 1st, so just a few days from today, proposes to remove the resource test. This has very widespread support up in Albany, so we anticipate this will pass, which would mean that right now you need to have less than $16,800 in order to apply for Medicaid. That means that if I have $50,000 today, March 24th, then by the end of this month, I need to deplete that $50,000 down to below $16,800 in order to be eligible. However, if this does pass, this change in resource test, then as of January 1, 2023, I will not have to deplete that money down to any amount. I can keep the assets in my name and I can apply for Medicaid. The nursing home still has a 5-year look back, and in the new proposal, it would remain the 5-year look back, which means if you transfer assets out of your name within 5 years before going to a nursing home, it will be deemed that you transferred it so that you can get Medicaid, and you will be penalized. There will be months that Medicaid won't pay for your care. And so that transfer penalty does not look like it will change, but again, there will be no asset test. You can keep your income if you are in a home care setting, but you have to put it into what's called a pooled income trust. It's a special type of account where your money can be used to pay your bills while you're living at home and receiving Medicaid funded home care. And then whatever has accumulated of your income during your lifetime will be lost at your death. In a nursing home, your income goes to the nursing home and Medicaid pays the balance. That is not proposed to change. That will be the same. The only difference is that if you are at home on home care Medicaid, you'll be allowed to keep more of your income in your regular bank account and have to divert less of it to this new special account under this new law. And so we're waiting to see what happens on that too. We should have answers within at least within a week or so, but the implementation date is unclear when that would actually be. I see some questions came in, so I'm going to stop and answer those questions now.
Perfect. We've got our first question, which is, how do you use the federal exemption now while it is 12 million or 26 with spouse, bearing in mind much lower New York State exemption?
Yeah, so this is, I will give a broad overview, but this definitely goes in the topic of if you are a person who has is concerned about using this exemption while it's high and before it drops down, you should definitely be speaking to your attorney. There are different mechanisms we use, and they're not really good in all situations. One example is we have something called a SLAT, S-L-A-T, a spousal lifetime access trust. It's a trust where one spouse can put up to the exemption level into a trust. It will be a lifetime gift that gets it out of their taxable estate. They'd be using their entire exemption, so there wouldn't be an exemption left at death, but the spouse can have access to that money, and it can be a use of that exemption level before it drops down. So that's one of the ways that we do it. Lifetime gifting is generally the way to do it. And if this person says, bearing in mind the much lower New York State exemption. So think about that. If you satisfy your 12 million, you put your 12 million into a trust that gets it out of your taxable estate, and you live 3 years beyond doing so, you will not have a New York State estate tax on that 12 million because you got it out of your estate and then you live for 3 years. So there's a lot of fun planning and interesting planning that can be done. It depends a lot on the relationship between the spouses. And the relationship, the trust, how they feel about doing certain techniques that really require a lot of trust between the parties. And it also depends on the type of assets you own. Someone who owns assets that are real estate versus LLC interests versus cash versus retirement accounts, these are all going to play into what kind of planning tools we can use. But that's the general idea of how you can make lifetime gifts and utilize your 12 million while it's that high.
Thank you. Next question. My siblings are in Europe. Is this way complicated for them to inherit?
So in general, I'll say no. It's not way complicated, to use the term from this question, but there are certainly considerations when you have foreign inheritors. I have an estate where I was actually the executor because the family all lived out of the country, and none of them could be executor. None of them could be appointed by the court. None of them could open a U.S. bank account for the estate. So they asked me to serve as the executor so that that could be done. And then I was able to, once I took in all the money, put it in the estate bank account, paid whatever had to be paid, I could pay checks out or make a wire transfer to those family members in another country. I had another case where it was the same kind of situation where I served because all the family members were out of state, out of the country. And the issue that came up in that one was that this woman had a decent amount of tax deferred retirement. And so we had to do a very large tax withholding, income tax withholding, when we made the distribution to the family member in the end who was overseas, because the United States wanted to make sure that they could tax that income. Because it was a foreign beneficiary, it had to be taxed at a high rate. So it wasn't that it was too complicated, but it certainly has its complications that require attention. And I would say if that person has US people that they would like to inherit their estate, and non-US people, you might want to be smart about which assets are left to which person.
Thank you, Britt. Next question. Can an executor live in another state? Is this problematic?
An executor can live in another state, and it's not usually problematic. In Florida, I'm told, I'm not licensed in Florida, but I'm told by my colleagues in Florida that in Florida, you actually can't be appointed by the court as executor if you do not live in Florida. But New York doesn't have that rule. But there are certain rules, like you have to open a New York State bank account for a New York State estate. And so that's something that might require a visit to the state, or cleaning out the apartment or the home, or wherever the person lived. So there might be things that require the individual to come into the state, but there's nothing that forecloses them from being an executor in New York because they live out of state.
Thank you. Next question. How does the power of attorney executor get paid?
Okay, I'm going to separate out those two questions because they're very different answers. The executor, I'll answer that first, it's easier. For the executor, we usually will state that if somebody wants the executor to have compensation, we'll usually state that they can have what we call statutory compensation. There is a statute that actually, a law that actually lays out exactly how an executor is paid and how much they are to be paid. And in general, it is based on the size of the estate. So, and the size of the assets that are handled. And so the other question is going to be what assets pass through the will, where the executor is in charge, and what passes pursuant to beneficiary designations. Because remember, probate and executors are only over assets in your sole name with no beneficiary. So if the bulk of your assets are passing by beneficiary designation, then the executor might not have very much to get their commissions based upon. With the power of attorney, it's interesting. So it kind of depends on the situation. Most often, to be honest, our powers of attorney do so because they're family members or close friends and they do not take monetary compensation. It's very hard to calculate the compensation that a power of attorney will use because it's often in effect for very many years without the power of attorney agent ever having to do anything. So the question is, when do they start getting paid? How do they start getting paid? I do have some clients who don't have family members who can serve as a power of attorney. And so they might hire, say, a daily money manager, a bookkeeper, et cetera, to be their power of attorney and appoint them, in which case they usually work out compensation with that individual like you would work out a contract.
There is one question that popped up. It says, when exactly is a power of attorney used?
Yeah, so it can be used in a lot of different circumstances, but essentially a power of attorney is used when the individual who gives the power wants or needs assistance. So because it doesn't rely on my incapacity, if I sign a power of attorney, I'll give an example. Often they're used if somebody needs to close on a house and can't make it to the closing. They can sign a power of attorney saying that somebody else can sign on their behalf. It can be used if I physically have trouble getting to the bank, or if it's hard for me to hear on the phone and I have to call an insurance company in order to make a claim. I might want my power of attorney to step in and act on my behalf. Or it can be used if I'm fully incapacitated to handle all of my financial and legal affairs. Thank you for joining us today. I think that as Burner Law Group, we are all female attorneys, and our support team is almost fully female. We have some males on the team as well, but we're really sensitive and want to pay attention to the fact that women look at these issues differently often than men, and that women really are the caregivers and the decision makers in a lot of situations. And so when sitting down with your attorney, you want to make sure that your you're being paid attention to and what's important to you. All of our questionnaires ask what the goals are, because if I don't know the goals of the client, then I can't possibly provide them with solutions that are going to help them attain those goals.
Thank you everyone so much for taking time out of their day and joining us. If anyone comes up with any additional questions, please feel free. You can reach out to us at info@Burner Law, and we'd be happy to answer those for you. Hope everyone enjoys the rest of their day, and we look forward to meeting with you all again through the Westhampton Beach Library.
Yep. Thank you. Have a good day.